morning. It's Thursday, February 9th, and in my search for something to talk about this morning, I came across an article that deals with the women's right to an abortion. And it turns out that a federal judge has suggested that the 13th Amendment might be the way to give that right back to women. Now, we know that the Supreme Court overturned the 14th Amendment with respect to the right to abortion. But the 13th Amendment has certain sections in it that might mitigate what the Supreme Court did. Wouldn't that be an interesting thing if the 13th Amendment is used to overrule a ruling by the Supreme Court based upon the 14th Amendment? So this federal judge suggested that the right to an abortion, which the Supreme Court overruled last year, might be protected under the 13th Amendment. And this judge, Judge Colleen Kala-Kotelly, posed that hypothetical in a court order in a case against anti-abortion activists. And they were charged with blocking access to an abortion clinic in Washington, D.C. Now, we saw that happen many, many times where police were called in to stop people from blocking abortion clinics. That is something that has happened in the United States for many, many years. But now, with the 14th Amendment having been overturned, I don't know that there are many abortion clinics in many states that still exist, right? So here we have a federal judge that is raising the question again. Right? This judge happened to be appointed by Bill Clinton, and she asked attorneys to file briefs on the question of whether the Supreme Court's decision is limited to the 14th Amendment. Because if a brief says it's not limited to the 14th Amendment, then perhaps what the 13th Amendment says can be used to overturn the Supreme Court's ruling, right? And some states, the states went crazy when this happened. Some states have just moved to sharply restrict or ban access to abortion after that ruling in the case known as Dobbs versus Jackson Women's Health Organization or whatever. And those states went bonkers. They were so happy to stop women from getting abortions. Now, most of these states have highly religious people, and so the religion in the United States is not supposed to interfere with the lives of people. It's not supposed to interfere with the rights to other civilians. We have the right to choose, and religion is something that we can practice, but it's our own. It shouldn't be forced upon any other people. And the right to an abortion falls into that category. There are many who believe in the right of life, and it doesn't matter when that life occurred. But if the right to life restricts the life of somebody else, that's not a good thing. So in any event, let me refresh your memory about the 13th Amendment, and then I'll quote the certain section within it that covers this abortion case. The 13th Amendment was created by Abraham Lincoln, and it's the amendment that abolished slavery in the United States. And Lincoln was determined to have this amendment put to the Constitution before the 1864 election. And he succeeded in getting this amendment passed. And now let me tell you what the critical piece in that 13th Amendment is that allowed this federal judge to say that abortion may be perfectly okay, that we have no right to stop women from getting an abortion. The 14th Amendment clearly states neither slavery nor involuntary servitude, except as a punishment for a crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So essentially, Essentially, what this judge is saying is that forcing a woman to have a child is putting her in the position of involuntary servitude, and that is against the 13th Amendment of the Constitution. So there you have a wide open place to attack the Roe versus Wade decision. Now, I don't know what's going to happen since the judge threw it on a group of lawyers to write their opinions about the 13th Amendment. But involuntary servitude is certainly what you are asking a woman to undertake if you're forcing them to have a child. Because children need to be taken care of. Having a child is not a one-time deal. It's a lifetime commitment. And if you have a situation where either you can't mentally wrap yourself around taking care of a child, or you can't afford that involuntary servitude, then you should be entitled to make that decision for yourself. Nobody should be forced into that particular personal entrapment, making you responsible for a human being that you really, really didn't want. That's like putting you in handcuffs for the rest of your life. So this judge has opened a can of worms that is certainly worth exploring. And wouldn't that be a wonderful thing? Because then it would go before this Supreme Court and probably be overturned again, because these people on this court have no concept. I believe that the people on this Supreme Court are extremely right-wing, and I know that Comey Barrett is a very religious person, and I believe she lets her religion interfere with her judgment on cases. But that's a whole other thing. This is a strictly very conservative court, and we will be saddled with it for a long, long time. So in any event, I think this is a terrific idea. I think it shows that we are still a country where freedom can be achieved if one has the intestinal fortitude to pursue it. So I leave you with that this morning. A possible way around Roe versus Wade's failure, so to speak. Have a great day. I'll see you in the morning. Bye.